All right, I believe we are live. Good morning. It's February 25th, and I'm Senator Stacey Brenner. I'll be presiding over this briefing of the Joint Standing Committee on Environment and Natural Resources. Only committee members, the committee analysts, and those specifically invited to attend will be participating in the briefing using Zoom today. For members of the public wishing to observe, this meeting is being live streamed on the committee's YouTube channel and will be recorded for viewing after this meeting concludes. We're also broadcasting the audio of the meeting on the legislature's website, www.legislature.maine.gov. I'd love to start with introductions as per usual. And Representative Bell, we'll start with you.
Good morning. Representative Bell, Art Bell from Yarmouth, Chesapeake, and Long Island, House District 47.
Thank you. Representative Ziegler.
Representative Paige Ziegler from District 96, the 7 towns of Belmont, Liberty, Lincolnville, Montville, Morrill, Palermo, and Searsmont.
Representative Dudera.
Good morning, everyone. I'm Vicki Dudera. I represent House District 94, Camden, Rockport, the island of Islesboro.
Representative Bloom.
Good morning. I'm Representative Lydia Bloom. I represent House District 3, New York.
Representative O'Connor.
Good morning. I'm Representative O'Connor. I serve the individuals of House District 5, which is Berwick and part of North Berwick.
Senator Bennett.
Thank you, Madam Chair. I'm Rick Bennett. I have the honor of serving some wonderful people of Western Maine in the Maine Senate.
And Senator Carney.
Good morning. My name is Ann Carney. I represent Senate District 29, which is the community of South Portland, Cape Elizabeth, and part of Scarborough.
And my co-chair, Representative Tucker. Oops, you're muted.
Thank you very much. My name is Ralph Tucker. I represent House District 50, which is 1/2 of the town of Brunswick. Thank you.
And we're also joined today by Dan Tartikoff and Sabrina Carey. Dan is our analyst and Sabrina is our clerk. And we will be lost without them. So today we've invited Acting Commissioner Melanie Loisum and Assistant Attorney General Scott Oak to brief the committee on the decision that the minor revision application for the New England Clean Energy Connect project does not require the Board of Environmental Protection to assume jurisdiction over the project. In the past 24 hours, questions from this committee have come to my attention, and Chairman Tucker and I worked quickly to arrange for the briefing to get these questions and concerns addressed as soon as possible. We thank Acting Commissioner Loisum and Assistant Attorney General Boak for making themselves available on such short notice. And we've budgeted an hour of time for this briefing today. In that hour, we will hear from the Acting Commissioner and the Assistant Attorney General. Each committee member will be afforded at least one question and one follow-up. Should time allow, we will offer additional time for questions at the end of the hour. Acting Commissioner, thank you for coming on such short notice. We appreciate your time and flexibility, and the floor is yours.
Thank you, Senator Brenner, Representative Tucker, distinguished members of the Environment and Natural Resources Committee. I'm Melanie Loisum, Acting Commissioner at the Department of Environmental Protection. Thank you for inviting me here this morning to, as Senator Brenner described, provide some additional information regarding a recent letter issued by the department regarding requests for board jurisdiction of a minor revision application pertaining to the New England Clean Energy Connect project. I thought I would take a few moments this morning just to walk you through the timeline associated with the project and the minor revision application, as well as some of the procedural requirements that apply to those. The original Clean Energy Connect project application was received by the department in 2017. At that time, there were no requests for original board jurisdiction of that application filed with the department. The department did decide to exercise its discretion to require that a public hearing process be implemented. And so a public hearing was held with a department hearing officer managing that process. In June of 2018, the department issued notices requesting interveners to participate in that process. Then in 2019, April 1st through the 5th, and additionally on May 9th, there were a total of 6 days of public hearing conducted on the application for the full project. In March of 2020, the department issued a draft order approving the project proposal. And on May 11th, 2020, the project permit was approved. On June 10th of 2020, that permit was appealed to the Board of Environmental Protection, and requests for stays of the permit were filed. The State Superior Court denied the request to stay the department's permit approval. The Federal District Court did approve a stay request for the Army Corps permit pertaining to Segment 1. And so at this time, due to that stay, work is occurring instead in Segments 2 and 3. And the work that is occurring is not involving any of the changes that are proposed in the minor revision application. The minor revision application was received and accepted as complete for processing by the department on January 5th of 2021. And for a moment, let me just explain what accepted as complete for processing means. It means that there's sufficient information in the application for the department to commence its review of what's being proposed. Though it does not necessarily mean that all information that is needed to make a decision has been supplied with the original submission. It is common practice for the department to request additional information while they are processing a permit application. So we receive a great deal more information through review of the application often than we do with the initial application. At the time that we received the application for the minor revision, although there was no requirement for there to be public notice for a minor revision application, the department did send notice to all of the interested parties that were involved in the original hearing. So the same service list that was getting notice associated with the broader project also received notice of this minor revision application. Now, in accordance with the department's rule, Chapter 2, Section 17, it provides the commissioner with 45 days from that date of acceptance to make a preliminary determination about board jurisdiction. So the deadline for that decision was February 19th of 2021. There's also a 20-day deadline for requests for board jurisdiction. So that deadline closed January 25th. And in that time, the department did receive 2 requests for board jurisdiction, which are the subject of the letter that is the topic of our conversation today. So on February 10th, I issued the letter that I believe you have all seen at this point, and would like to highlight that the nature of that decision is based on a request for board jurisdiction of a minor revision application. At this time, the department has not completed its review of that application. It may be determined at a future date that that application does not meet the definition of a minor revision, in which case the application would need to be resubmitted as an amendment, and there are other processes that would be followed to process that application as an amendment. So because of the timeframes that are imposed by statute and by rule for making a decision about board jurisdiction, the decision was based on the idea of this being a minor revision before we've had the opportunity to make a final decision about whether it really qualifies as a minor revision. Now, I'll quickly go through what qualifies as a minor revision under the department's Chapter 2. That's an application to modify a license that was previously granted by the department. So a minor revision isn't to revisit the project as a whole. It is to make small changes to an already licensed project. And that modification may significantly decrease or eliminate an environmental impact. It does not significantly expand the project, does not change the nature of the project, or does not modify any department findings with respect to the licensing criteria. So at this time, the department is engaged in reviewing that minor revision application against those criteria. Would also note that the commissioner's letter, my letter making a determination about board jurisdiction, has been referred to the Board of Environmental Protection. And the statute does provide for a process where the commissioner conducts this review, notifies the board, and then the board may also take up that same review of whether or not it meets the 4 criteria for board jurisdiction, which include concepts like significant public scrutiny and projects of statewide significance. The board is scheduled to take up that conversation on March 18th. And so with that, I would be happy to answer any questions.
Senator Carney.
Thank you. I'm sorry, I should have used my mechanical hand and I used my real one.
We like your real hand too.
Thanks. Thank you for being here, Acting Commissioner Loisem. I guess I wanted to just clarify. I've looked through the February 10th correspondence, and it goes through a lot of different analyses, so I had a little bit of a hard time tracking it. But I think what you've told us today and what the letter says at the bottom of page 3 is that there is this outstanding issue of what CMP submitted to you in, I think you said in January, is a major versus minor, and that decision actually has not yet been made?
That is correct. Yes, that's still the subject of ongoing review at this point. And I would note that we have, for instance, submitted requests to CMP for additional information to further evaluate the information that's been provided and compare that against the definition of a minor revision. And so there is information that is currently coming in from the applicant to assist us in continuing to conduct that evaluation.
And then just, can I have a follow-up, please? And can you please clarify who makes that decision? Is that made by the Department of Environmental Protection or by the Board of Environmental Protection?
The law provides for both. So a request for board jurisdiction can be filed directly with the department as well as with the board. The commissioner is the one directed by statute to make that decision. Obviously, that's not a decision that any wise commissioner would make on their own without consultation with their project review staff and legal counsel and others involved in consideration of the project as a whole and the application. And then it can also be considered by the board, which is what is still pending. And so this conversation we are having is happening in between those 2 stages of first the department having a deadline to make their preliminary determination, and then the board taking that up for further consideration.
Thank you.
I have a question for you, Ms. Loisem. We have a part of the letter that was concerning related to section 1 around the 4 criteria for a project of statewide significance. And one of those criteria was specifically about public scrutiny. Could you speak to that, please? Certainly. At the time that the letter was issued, the department had received 3 comments regarding the minor revision application. We have, over the course of handling the original project, as well as all the time that has passed since then, regularly received comments from people that are about general opposition to the project at large. And the question that in this case we have to focus on is trying to discern the substance of those comments that actually pertain to the changes that are proposed in the minor revision application and are not concerns or questions being raised about the broader project, which I should note the Board of Environmental Protection will be taking up the appeal of that broader project permit here in this coming year.
Thank you. Representative Dudera.
Thank you. Thank you, Acting Commissioner Loisem. Can you just, your list again of characteristics, I guess, of when you would determine that something's a minor revision. You said not change the nature, not modify, not expand. I missed one of them, and I just wanted to hear that list again.
Sure, happy to. So this is in the department's rule, chapter 2. It's the definition of a minor revision. It's an application to modify a license previously granted where the modification significantly decreases or eliminates an environmental impact, does not significantly expand the project, does not change the nature of the project, or does not modify any department findings with respect to the licensing criteria.
Okay, and may I have a quick follow-up? Thank you, Chair.
Yes.
So how you have proceeded on this particular project with this minor revision, is this consistent with how you would have done this for other projects in the past?
Yes, we are handling this consistent with the same processes and procedures that we would apply to any minor revision, with the slight addition of providing public notice of receipt of the minor revision application, although such notice isn't actually required for a minor revision application.
Senator Bennett.
Thank you, Madam Chair. First of all, I just want to say thank you for holding this meeting. I know it was rushed and all of that, but it's very important. And I know I raised some concerns. And in the context here for everybody who may be paying attention is that Acting Commissioner Loisam's confirmation vote is scheduled for later today in the first meeting of the State Senate. And this is one of the matters that we're taking up. The letter, which obviously has got a lot of attention because it's brought us here today, was dated February 10th. And we were unable to ask questions of the acting commissioner about this letter because the confirmation hearing was on February 8th, the letter February 10th. So I'm grateful for the opportunity. I also want to say at the outset, I appreciate the acting commissioner. I raised some of these concerns with her in a phone call yesterday, and she was very responsive, and I'm grateful for that. So I just want to delve into this question. There's one line in this letter, which as I indicated to others, is really concerning to me. I mean, it is on page 3, and it says the minor revision application has not come under significant public scrutiny. And I think there's a lot of question about that and how that conclusion was drawn. And the letter goes on to say, for example, the department has received comments from 3 groups: the Natural Resources Council of Maine, Sierra Club, and the West Forks Plantation Intervenor Group. And I get the difference, the nuance between the minor revision and but the NRCM, the Sierra Club, these West Forks Plantation, these represent thousands of Mainers. And I just wonder, what is your criteria in general, and particularly relating to this particular decision, since it's before us, what is your criteria to make these determinations of what is significant public scrutiny? Because there's many people concerned about this project that rely on the leadership of the NRCM, the Sierra Club, and others in giving voice and representing them. So could you give greater clarity on that?
Certainly. So the comments that were received requested the board jurisdiction, the comments from NRCM and Sierra Club, and all of the comments, not while they were targeted at the minor revision application, because that was the application that was available for comment, they do all still go back to concerns regarding the original application as well. And so, as I said, it's important for us to try to evaluate to what extent the comments that are being provided truly pertain to the substance of the application that is currently before us. And they did not provide much detail in that way, other than the question that we are still grappling with is, are these changes truly insignificant that are being proposed? And that's what's currently under review. So they do raise a valid question, as I've heard already numerous times, characterize such a voluminous document as a minor revision. You know, on the face of it, that seems like a hard thing to align. And so there is significant review being undertaken to determine whether or not it would qualify as a minor revision. And those are some of the concerns that they raised in their comments to us.
If I could follow up, there is, this minor revision, supposedly minor revision, which CMP has put to you and all of us here representing the people, is 692 pages. With the attachments, it's 119 pages. I've actually read a good portion of it, and it doesn't strike me as minor. And I think anybody that looks at that is going to say, like, how can they even claim that it's minor when, if the revisions themselves were put before the department, they would be a major thing, a major project. And so can you provide some clarity as to how this could be viewed, even presented as a minor revision in the first place? Because a lot of the letter, as you stated, at the end of the letter, you haven't drawn that conclusion whether it's minor or not. And a lot of the go forward process is going to depend upon that decision.
Certainly. Many of the changes that are proposed in the minor revision application are things like placement of a pole, either moving it linearly along the already planned line. So if the pole was going to be in one spot, maybe it's 2 feet to the north or 2 feet to the south. There are also lateral adjustments, 2 feet to the east or 2 feet to the west. These are things that happen on a regular basis regarding construction projects all across the state. So for your standard large construction project, when they begin to do the work and preparing to do the work on site, oftentimes these field adjustments are required. So for example, in the MPRP project, which was permitted in 2010, there were 17 minor revisions that were issued to that project. That project was much larger in length and the number of communities that it passed through. And all of those types of field adjustments that are similar to what's being proposed in this minor revision application were permitted as minor revisions through the course of construction of that project. In this case, one of the things that the department requested of CMP was, rather than piecemealing it, that whatever they know that they believe they would need to make adjustments to should be submitted to us as a comprehensive package for our consideration up front. For example, some of those line movements required redoing the photo simulations. So all of the base photography remains unchanged, but part of the evaluation has to include, is there any kind of adverse visual impact? So those photo simulations were redone to show the pole moving ever so slightly in one direction or another. It has required our staff to look at the original records side by side with each element of what they've submitted to determine page by page what the true nature of those changes are, and that's still ongoing.
Representative Bloom.
Thank you, Madam Chair. So if I understand correctly, Commissioner Loisem, what you're saying is that these are very minor, this application, no matter how large it is, the actual request is for minor changes from 1 foot or whatever to another. It's not a substantial difference in what they're asking for example. Is that correct?
That is what they have proposed, yes. And so that is what is currently under review, is to confirm that each of those changes that have proposed do truly meet that definition of a minor revision.
And how long is it going to take for you to, you've requested information, you haven't made a decision yet. How long do you anticipate the process to go?
I couldn't give you a definitive date. I am aware that we only recently received some additional information from CMP in response to some of our initial questions. I would anticipate that there will be more exchanges of that nature. So I would only speculate that this will go on for several more weeks, at least, to continue our evaluation.
Thank you.
Has anyone who hasn't asked a question yet have something that they want to touch base on with Ms. Loisem? Yes, Representative Tucker.
I would like to know to what degree were attorneys and other staff members at the department involved in constructing and drafting this letter, and
Sure.
how long it would take and so forth.
Yep. So the application was received and accepted for processing in early January. The project lead, Jim Byer, was involved in the initial drafting of the letter with review by his bureau director, Nick Livesey, and his colleagues. It was then reviewed by the Attorney General's office with edits made. The baseline substance of the letter is one that is common to board jurisdiction determinations by the department on other minor revision applications. So the criteria that are set out in law come up from time to time in terms of board jurisdiction requests. And so we have a somewhat templated piece of correspondence that is then used to make it specific to each of the project details that are coming before the department for consideration. So that templated language has long been reviewed by the Attorney General's office. This letter was an initial draft that I saw of it was dated January 22nd, and it was very much in its early drafting form at that stage. The final version that was prepared for my signature was provided to me on February 10th. And so the letter was not complete and final and ready for signature until that date.
And my follow-up is, did your staff and the attorneys recommend the content of the letter to you?
Yes, they absolutely do. And we did engage in discussions about it. I had some of the same questions that you all have had about the content of it. We've certainly had further discussions about it since then in preparation for bringing the matter before the board as well. So this is a topic that has had significant conversation amongst people with law degrees that I do not have, picking over every bit of the word choice to make sure that this does not run contrary to other precedent and is not inconsistent with how we've handled other projects.
Thank you.
Representative O'Connor.
Thank you, Senator Brenner, and thank you, Ms. Loisem, for being here with us today. I just wanted to state for the record that I think this is an extremely important meeting. I think anything that we do and we do publicly like this, we should have a lot more notification on it. I know that I had to juggle a lot of things to be able to be here this morning because there was no notification, as well as quite a few other individuals who would have liked to have been present to hear what was said would like to be here, but we're juggling some really difficult schedules, many of us, and I'm quite sure that you all are as well. I don't have any questions as of the project and what's happening right now. I'm quite sure that I will. And I think more up to date when we're going to schedule or have meetings like this, that we should have all of the information that possibly will be discussed in front of us before it happens. Sometimes we put things in folders that are, I know that I'm juggling hundreds of folders right now, just like you all are, but I really want to thank you for being here today. And, but in the future, for my esteemed colleagues, I would really appreciate some better notice for these meetings, but thank you.
Thank you, Representative O'Connor, and I will own that and take it to heart. Any other questions from folks who have not asked anything yet? Not seeing any. Senator Bennett will entertain another question.
Thank you, Madam Chair. So I appreciate the line of inquiry regarding when to listen to lawyers, and not being a lawyer myself, like you, Acting Commissioner Loisem. It's always a perilous thing, right? And I do think that there's some parts of this letter that are frankly over-lawyered, and this project needs to hear the voice of the people. And that's why I return to this question of public scrutiny in a couple of questions follow-up. Why does the department think it's appropriate to look at the amount of public interest in an individual filing related to a project when the statute itself refers to the public interest in the overall project?
In this case, the way that it has long been interpreted is that under that provision of the statute, what is defined as the project is the work that is described in the application before us. And so in this case, the application before us is the minor revision application, not a revisiting of the larger overarching project itself. So for example, in a transfer application, which has been processed by the department and has been consolidated as part of the board's appeal, a similar determination was made that the transfer application did not qualify for board jurisdiction in that case because the project was considered simply to be the legal transfer, again, not having to do with the overarching project and the work on the ground.
I think you indicated to me yesterday that the project it will have the opportunity to be reviewed by the Board of Environmental Protection. And
Yes.
Is that an appeals process that has to be initiated by them, or is that an automatic thing?
So the board will have a couple of opportunities in front of them. One is the one that we discussed already, to decide whether they believe that the minor revision application meets the criteria for board jurisdiction. If they do not take board jurisdiction, and if the department were to issue a permit, either a minor revision or an amendment to the license, that could be subject to appeal, which could then be brought before the board.
Thank you. I see that another member has a question, so I'll defer.
Senator Carney.
Thank you very much. I don't know if this is a part of the letter that you're familiar with, or the attorneys for the department or the AG worked on, and I didn't see the response from CMP, but at the top of page 3, the letter talks about CMP's argument is that basically minor revisions are never projects of statewide significance, and so the BEP never has jurisdiction. And were you rejecting that argument and saying, no, this is a case where the BEP may very well have jurisdiction?
Thank you, Senator. In this case, we actually effectively set aside that question for the purposes of making this decision, because by its nature, if an application qualifies as a minor revision, then it should not be a significant change to the underlying project. And so we determined that we did not need to try to tackle that question about whether Chapter 2 gives the board authority over minor revision applications.
Thank you. I don't have any follow-up. Thanks a lot.
Great. And Senator Bennett.
Thank you, Madam Chair. I think one aspect of this whole project, which has been very frustrating for my constituents and people across Maine, is they don't feel like their voice is being heard. And I think it would be really helpful for us to use this forum, and Commissioner, if you could share with us exactly what happens when somebody writes an email, expresses themselves on a project like this. What is the right time for them to communicate? What do you do with that communication? I mean, individual emails, what's the best way for people to talk? And, you know, because it seems inadequate for them to talk just through a group like the NRCM. Could you go into some granular detail exactly what you do when you get comments?
Sure, I'd be happy to. So for this project in particular, we have a website on our DEP webpage that's dedicated to it, and it includes an email address. So that, you know, the idea would be if someone is Googling and trying to find out what is going on, that our page should come up as one of the top results. And then there is an email address that is provided. So that is a mailbox that is checked by the project manager for the project, as well as other staff. Every single piece of correspondence is reviewed. And part of the reason that, regardless of the nature, so for instance, we get hundreds of form letters, let's say, about a project. Occasionally, someone will make a minor tweak to the substance of that form letter. We can't just click through and say, oh, that looks the same as the last one. Each one of them has to be reviewed, because there can be times when things like a records request could be included in one of those pieces of correspondence. There could be something that's identified that is substantive and impactful information. Questions about title right and interest on a piece of property, for example. So every piece of correspondence has to be reviewed, filed, indexed, and then for projects like this project and some others, if we anticipate that following a board decision, there's any potential for litigation, they all also have to be indexed in preparation for providing a court record. And so every single piece of correspondence is reviewed by someone. That someone is one of our Land Bureau licensing project managers who is also trying to juggle other projects at the same time.
Good. I'm glad you switched from the passive voice to identify who is actually doing that, because I think that's what people want to know. You know, who's actually doing it. But
Let's take a moment to switch gears for Representative Bloom.
oh, I was just right in the middle of that, but fine.
Okay, Representative Bloom.
Thank you. The larger project that we're talking about here, not the project that's being applied for, not the minor revisions, but the larger project involves other departments aside from the DEP. Is that correct?
That is correct.
And what other departments are they that are involved?
For any of our site location of development and Natural Resources Protection Act permits, those are submitted to other agencies to assist with review, including Inland Fish and Wildlife, Department of Marine Resources, the Historic Preservation Commission. We also work in coordination with the Army Corps of Engineers where there's any identified potential wetland impacts.
So if someone has a problem with any of that the DEP is not necessarily the only department that they should be addressing?
Correct. The way that the system is set up, for instance, regarding wildlife impacts specifically, is that the department does not employ wildlife biologists. The Department of Inland Fisheries and Wildlife does. And so we utilize their expertise to provide us with recommendations and review of the materials that are specific to wildlife. It's a similar set of circumstances regarding sea-run fish and Department of Marine Resources, for example. It would be inappropriate and uncomfortable for DEP to be taking a position on those kind of protected natural resources that might differ from those agencies that are tasked with protecting those resources. So we rely on their recommendations, and those are all included as part of the record for the permitting decision.
Thank you.
Senator Bennett, we'll circle back around again.
Thank you. So the question of public scrutiny, I guess I want to say one thing and then ask, and I just have one other question. Your letter states and the statute states that a project of statewide significance is a project that meets at least 3 of the following 4 criteria. Will have an environmental or economic impact in more than one municipality, territory, or county. Check that box. Involves an activity not previously permitted or licensed in the state. Maybe not check that box. is likely, we don't know yet, right? Is likely to come under significant public scrutiny. That one, I think, stated boldly is certainly true. And that's where the difference is. And finally, is located more than one municipality or territory or county. On the slender read of this significant public scrutiny, this project has not gone to the BEP, and I think it should. Now, let me just finish with my question, which is this. I'm curious as to what happens going forward. If you mentioned title right and interest, if the title right and interest is lost in a permit, would the DEP suspend the permit until the situation has been rectified?
If a permittee does not have title right and interest to undertake the work that they have been permitted to do, then that would violate a condition of the permit, because one of the findings in the permit is that they do have title right and interest.
So what would happen in that case?
So if they lost title right and interest, they should not undertake work on the section that they do not have title right and interest for. They would need to come back to the department to identify what they do have for rights to engage on that engage in that activity in order to utilize that permit authorization. The authorization is based on, as a condition, that they have the right to do the work in that location.
Just for absolute clarity on this point, the project can go ahead even though it's violated one of the terms of the project, the approval, you're saying you could actually compartmentalize the project? I mean, is that what you do? So if somebody's building some other thing subject to this law and they lose title right and interest to part of the land it's sitting on, then you're good with them building the rest, even though it may impact that area or have an uncertain outcome?
So typically we're dealing with a singular location, not a corridor project. But in a corridor project, as I believe you're all aware, that in and of itself involves, in some cases, some piecemeal pieces of work. So the overarching project approval includes, for instance, not one singular line, but other separate segments that are being worked on. And so if the title right and interest to a particular parcel that's already been approved changes, they can submit a minor revision application to provide additional evidence of existing title right and interest to proceed with that licensed work. And so that's part of the review that has to be done by the department.
Okay, could you check that for me? I don't want any misunderstanding about this question. And if you can confirm that answer for me in writing, that would be most.
I would be happy to. I'm sure that I have folks who are listening who are working on providing an answer to that right now.
Thank you.
Are there any additional questions for Ms. Loisum? Any additional?
May I make a statement?
Yes, please.
This is a very interesting discussion because the function of our legislative committees are really threefold. We usually we consider and recommend laws. We have confirmation hearings, and we also have an oversight function. At the present time, however, we are, I believe, doing the oversight function. We were advised that there was a small uproar among some legislators over the recent legal letter from the department. The letter concerned the permitting of changes in the works of the CMP project. Because the project is a hot political issue, obviously every twist and turn is going to be examined under a microscope in the context of opposition or favoritism to the project. This letter that is under discussion today, which appeared 2 days after the confirmation hearing, appears to me to be a well-drafted analysis from the DEP on how a permitting issue should be handled, citing several statutes. Although it's signed by the acting commissioner, in fact, it's a product of the entire department. Interested parties may disagree with the analysis, but the letter addresses the questions raised in direct, clear, and to-the-point language. So just a reminder to everybody, there's no bill before us right now. The CMP project is not before us today as legislation. We're not wearing our lawmaking hat today. In the past, it has come before this committee. And in fact, in the 128th, I joined with the chairman of the other chairman of the EUT committee and ENR in a letter opposing the project. And then we had LD 640 in the 129th, where this committee voted 10-3 that there should be a further study. We went through 7 roll calls ending in June 6, 2019, which failed for the 2/3. But we're not here to discuss that whole project today. That's not why we're here. We're also not here specifically on the confirmation. The confirmation process, as far as this committee is concerned, is done. The vote was unanimous. The candidate showed extraordinary qualifications, long experience, a can-do attitude, and refreshing candor. So we can't reconsider the confirmation vote. And in fact, it would probably be bad policy to reopen in any case. This would render the hearing process on confirmations useless if opponents of a specific project could ambush nominees with new issues following the hearing process. So what is the concern? What is wrong with this letter? Has the DEP functioned properly? I've seen no evidence of bias, of incompetence, of corruption, of neglect, of any lack of integrity. Would any administrator have done anything differently based on the advice from the Attorney General's office and the staff? As a political opponent of the CMP project myself, I see no serious failure on the part of Deputy Commissioner Loisem and her staff. So thank you very much for participating in this oversight briefing, Deputy Commissioner.
Representative O'Connor.
Thank you, Representative Tucker. That was very, very well stated. I appreciate that greatly. I do not have a problem with that at all. My only problem is with what I believe was a lack of transparency in the announcement of this. And I will go back through my folders and look for the more documentation. But thank you. That was very well stated, sir.
Representative O'Connor, I will make certain that you have all of the documentation in your inbox. And I do appreciate your frustration, but we had only received notice of this letter shortly after noon yesterday, so there hadn't been a lot of time for consideration. So I appreciate your understanding and your patience. Thank you.
Thank you.
Representative Dudera.
Thank you. I want to echo what Representative O'Connor said. Thank you very much, Representative Tucker. That was, I think you articulated what all of us, well, at least what I am thinking. So thank you very much for saying that. And I want to applaud our chairs of this committee for setting this meeting up and thank Acting Commissioner Loisem for being here today to answer our questions. I realized this was, tough to do under short notice. I had to juggle things as well. And some people unfortunately were unable to do that, but I do appreciate the effort that everybody made to get us here. Thank you.
And we'll take one last comment from Senator Bennett.
Thank you. And it will be my last. I want to say I appreciate the chance to have this hearing or this briefing and to hear again from the acting commissioner. I subscribe to much, although not all, of what Chairman Tucker said, because I do disagree with this letter. I do appreciate this opportunity, and I think that the one failing of this entire issue has been an immense amount of feeling and pent-up rage over this project, and a feeling among people that every time they get close to their voice being heard, it's shut down. And so I appreciate this opportunity that you've arranged, Madam Chair, Mr. Chairman, to get at least a small bit of public accountability around some of the decision making. Admittedly, this is one small piece of a big project, but getting something here is an improvement, and I think people will appreciate it. So thank you.
And with that, Ms. Loisum, I want to thank you so much for joining us today. I really appreciate everyone making time, and I very much look forward to supporting you this evening in the Senate.
Thank you all very much. I would just note in closing that I welcome opportunities like this to engage in conversation about projects where someone has a concern or a question. I feel like all of us are committed to public service and trying to do things in accordance with the laws that you all write and the rules that then we adopt to implement those. And when any one of you with your expertise and your perspective feels like there's something that is awry, I appreciate having that raised to me and to the staff. I think that that is information that is always helpful for us to have, and we're very open to that kind of communication. So thank you, Senator Bennett, for raising it, and for all of you for being part of this conversation.
All right. Thank you all so much.
Thank
See
you very
next week.
much for being here today, Commissioner.